Should you create a second LLC or use a DBA for your healthcare business? Hello, I'm David Holt, and I am a healthcare attorney at Holt Law. We've been doing this for over 10 years, and we are the law firm built for healthcare businesses. Today, I'm going to answer a question I get asked a lot. Should you create a second LLC or just use a DBA for expanding your healthcare operations? And I had a client ask this just the other day. It seems like a very simple question, but there are some pros and cons that I want to go over. So, first off, let's discuss the key considerations when deciding between a DBA and a new LLC or legal entity, focusing on the unique needs of a healthcare business. So first, let's face it, healthcare is different. First, what is a DBA? Well, DBA stands for doing business as. It's essentially an alias for your existing legal entity. For example, Dr. Smith's medical practice doing business as Smith Telehealth. Each state has a process to register DBAs known as assumed names. Now, what are the benefits of a separate LLC in healthcare? Number one, liability segregation. This is crucial in healthcare. A separate LLC isolates liability. If a malpractice issue arises in one area, your other practices are protected. This is similar to why many healthcare providers use separate LLCs for each physical location or specialized service. Number two, clarity and organization. Separate LLCs can simplify financial management and compliance, especially important in the complex regulatory environment of healthcare. Of course, there are downsides. What are the disadvantages of a second LLC? Well, you'll have an increased administrative burden, separate accounting and tax filings, and potential regulatory compliance for each LLC, not to mention potentially separate healthcare licenses. And of course, additional costs both for your CPA and attorney. So what are the alternatives to a second LLC? You could use a DBA, right? While simpler, it doesn't offer liability protection. All operations are under the same legal entity. Or you could rely on insurance. Adequate malpractice and business liability insurance can mitigate some risks, but it doesn't fully replace the protection of a separate LLC. And if it's available in your state, consider a serial LLC. This allows for multiple sub-entities under one parent LLC, offering some liability separation with less administrative overhead. Now, when can one LLC be liable for another? This is a critical point. When assets are commingled, if you treat separate LLCs as one entity, courts may pierce the veil and hold one liable for the other. This is a massive risk and a big mistake. Keep very separate records and bank accounts. You're wearing separate business hats. And finally, can you use the same EIN for both LLCs? No. Each LLC or entity requires a separate FEIN from the IRS. In the healthcare context, risk management is paramount. Consider the risk level of a new service. Higher risk services like surgical procedures or new medical technologies probably warrant separate LLCs or entities. The potential for regulatory scrutiny. Now, separate LLCs can simplify compliance tracking, and most importantly, how much can you afford to risk? And is the cost of a new LLC cheaper than the cost of losing everything? Many healthcare providers start new services under their existing LLC and then separate them once they become profitable. This must be done carefully to avoid successor liability. Consult with an attorney to ensure proper structuring. It can be a little tricky. If you're considering expanding your healthcare operations, consult with us to determine the best legal structure for your needs. Don't forget to subscribe to our YouTube channel for more healthcare law insights or visit our website at www.djholtlaw.com. Thank you for your time.